Hello, welcome to today's video in which we will be planning an answer to a 20-marker negligence question. Let's get right in. The answer structure. You must know the structure of your answer before answering a question. So, you start off with a brief introduction, a quick summary of the main legal issues. So in negligence is usually looking over duty of care, breach of duty, and has the breach caused damage, and maybe remedies as well. And then you quickly sum up whether the claimant would be successful and if the tortfeasor would be liable. After your introduction, you should have about 4 paragraphs, depending on if the question is asking for remedies. If it's not asking for remedies, then probably 3 paragraphs. If it's asking for remedies, then 4 paragraphs. Each paragraph would be separated into duty of care, breach of duty, and has the breach caused the damage, which is the causation. So now if we look into each paragraph, how should each paragraph be organized? How should duty of care be organized? Well, first, you introduce the main legal issue that will be discussed in the paragraph. So, duty of care, that will be explained so the examiners know you're discussing duty of care in the first paragraph. And then you have a detailed explanation of the legal issue you're discussing. So you need a detailed explanation of the legal issue you'll be discussing, and that would be your AO1. After you've explained and described what duty of care is, you need to apply your AO1 to the scenario. So the second part of the paragraph would be the application, applying your description to the scenario. So you need to explain how the legal principle or the legal concept applies to the facts of the scenario. And that will be the AO2. And then any counter arguments you have in your mind, you should also include them at the bottom of the paragraph to get into the level 4 band. And that basically works towards your AO2, as it shows to the examiner that you're evaluating the strengths of your argument, explaining how it does and doesn't support your argument. And then you finish off with a conclusion. The conclusion should obviously summarize the main arguments made in the body of paragraphs, and it should provide a quick and clear answer to the question, which in this case would be the negligence claim, liability. Should quickly conclude with who's liable and for what reasons are they liable. Just go over the duty of care, breach of duty, and has the breach caused the damage. So now let's see our question. So first you read your question. Advise Dan whether he can claim successfully against Chris. Okay, so it's your run-of-the-mill negligence question. So Chris is the owner of a fast food stall. Dan bought some food from Chris's stall. Dan became seriously ill. Soon after he ate the food, he spent 2 weeks in hospital. It was discovered the food from the stall was contaminated. Doctors found out that Dan was very likely to suffer more than most people from the food poisoning. Dan eventually recovered from his illness, but found that he had lost £20,000 earning from his work. He also lost out on an expected promotion at work as he failed to attend an interview when he was in hospital. So now when you read this, you should be thinking about AO2. The AO1, the description of the negligence, duty of care, breach of duty, has the breach caused the damage. The AO1, the description, the explanation part of that should already be in your head, and you should already be ready to write that down. The bit you should be thinking about in your head when you're reading the scenario is the AO2. So you've got to be thinking how you are going to apply the AO1 and what cases you are going to use. That's all you should be thinking when reading the scenario. So right now, obviously, you'll be thinking of Robinson, but then you should be thinking of a second case because Robinson, basically, the legal principle of Robinson is that you can use any case to establish a duty of care. So in this one, I'm going to use Donahue versus Stevenson because it's pretty much an exact copy of the case. Person buys food from person who's selling food, and they get ill and lose out on earnings from work, then it's quickly established that Chris owes a duty of care to Dan straight away. He owes duty of care to his customers. Breach of duty, then I'm thinking breach of duty. So I've got to find out quickly the standard of care. Chris is a fast food owner stall, so he's going to be measured against other professionals in the same profession, in the same field. So he'll be measured against other fast food stall owners. And then risk factors will also be assessed. So what risk factors would there be? Likelihood of harm. Yep, that's pretty much always assessed. The doctors found out that Dan was very likely to suffer more than most people. When it says suffer more than most people, you have to be thinking of potential seriousness of harm. That's another risk factor because of this more than most people. And then cost and practicality would be another one, because he's obviously an owner of a fast food stall, so it's a business, so he has to obviously take into account the cost and practicality and measure if that outweighs the harm, and obviously it doesn't outweigh the harm, and he's not taken the proper precautions, or at least it's not said in this scenario that Chris has taken proper precautions to ensure that his customers won't get ill from food poisoning. And then due to cause of damage, you got to think factual causation, legal causation, remoteness of damage. So factual causation, but for, this one's an easy one, but for Chris's breach, Dan wouldn't have suffered from food poisoning, and he wouldn't have been sent to hospital, and he wouldn't have lost £20,000 from work and that expected promotion. So Dan wouldn't have been ill and ended up in hospital if it wasn't for Chris. Intervening acts. Were there any intervening acts? No, there were no intervening acts that could have happened here. Remoteness of damage. So, as we can see here, that Dan was likely to suffer more than most people. This doesn't break the chain of causation, as we can use the cases Smith v. Leach, Brain, and another case, Bradford v. Robinson Rentals. And that was the extensive injury, and the Smith v. Leach Brain, was take a victim as you find them, a lot like Bolam for criminal law. So now we plan our answer. So first it'll be duty of care. So what is there in duty of care? So I've pretty much gone over this before whilst we were going through the scenario. So this is how you plan in an exam, because you have no time. You need to plan whilst you're reading the scenario. You have to be reading the scenario and planning. So that means to do that, you need a lot of practice. So that means practicing a lot of past paper questions. But here I'll write a written plan for you guys. So duty of care, the first thing you think of is Robinson v. CC of West Yorkshire, and then Donahue versus Stevenson. Now obviously you first start off with a quick description of duty of care. Quick description and explanation. Robinson v. tells you how to establish duty of care. Donahue versus Stevenson's is the case we are going to use to establish duty of care in this particular scenario, and then to apply what we've described here on the left, our AO1, to apply that onto our AO2. We need to just apply it, and that's what's explained in Donahue versus Stevenson. Obviously you include more detail in your answer and you go to town with it. Next one is breach of duty. So in breach of duty, straight away, standard of care, Blythe v. Birmingham Waterworks. And Bolam, obviously, and the one for professional is Bolam v. Bolam v. Barnett, Fryan, HMC, something like that. I don't remember exactly. Risk factors. So which risk factors are there? Well, that's easy, because we thought about it whilst we were doing the scenario. So, likelihood of harm. And this one we could use good old classic Haley v. London Electricity Board. Potential seriousness of harm. Then practicality. And this one you can include Latimer v. AC. And you can include the one in this one is, if I remember correctly, Paris v. Stepney Borough Council. So now we apply what we've described for the AO1 on to the scenario. So the standard breach. the standard of care. So what is the standard of care? Well, when we were looking at the scenario, it was quite obvious that the standard of care was of other food stall owners. So other fast food stall owners. That's who Dan would be measured against. Okay, so professionals of their own field. They're professionals of the field. Okay, so that's the breach of duty. Then we look at the risk factors. So what can we say for the risk factors? How can we apply that to the scenario? Well, let's look at the likelihood of harm. What happened in Haley? What's the legal principle in Haley v. London Electricity Board? Well, the legal principle was that basically to do with greater precaution. If there was a greater risk, then you need a greater precaution. Here, there was a risk, and so there's a need for precaution. And there'd be some set precaution, some standard of precaution that Chris would need to follow. And if he hasn't followed those basic necessary precautions, well then, he'd be in breach of the duty that he owes. Let's look at potential seriousness of harm. What's the potential seriousness? As we said, whilst we were looking at the scenario, when we saw that here suffer more than most people, we know straight away that it's potential seriousness of harm. Paris v. Stepney Council. Dan has underlying conditions. There is a potential that Chris may feed someone who has these underlying conditions, and Dan are one of these people who has these underlying conditions. I'd probably structure it the other way around. Say Chris may feed someone who has underlying condition. Okay, and then cost practicality. Cost obviously doesn't outweigh. I'm not right, obviously. Cost doesn't outweigh the risk of harm. It just simply doesn't. And you could end it basically saying Chris needs to take more responsible precautions. More responsible precautions could have been taken. It was quite obvious that Chris hasn't really taken proper precautions to ensure that people do not become ill from his food that he is selling. And then, from breach of duty, we go into damage. Straight away, factual causation. Oh, and I forgot to mention description for damage as well. Description or an explanation. I'm just going to write explanation, confuse less people. And same for the breach of duty. That would contribute towards your AO1. Factual causation. The case for that is Barnett v. Chelsea Kensington Hospital. Can't believe I remember that one. Then you got legal causation, which is your intervening acts. But you do not need to go into the 3 intervening acts. That's going too deep. And if there are no intervening acts, you don't need to cover the intervening acts. Just simply state there are no intervening acts between the tortfeasor and claimant. So it doesn't break the chain of causation. Remoteness of damage. Let's see. Remoteness of damage. There's your wagon mound. You can use wagon mound to help you explain it. Then you could also use Smith v. Leach Brain to talk about taking your victim as you find them. And then what was the other one I mentioned? Bradford v. Robinson Rentals, which was about extensive injury. There you go. And then to apply this, okay, quickly think. Factual causation, Barnett, that's but for test. Same as White in criminal law. Really quick. But for Dan wouldn't have fallen ill of food poisoning and went to the hospital, lose his money if Chris hadn't sold him contaminated food. It's not too hard to prove because it's really self-explanatory. You don't really need to focus on this one too much. The next we go to legal causation, intervening acts. There are no intervening acts. So, chain of causation not broken. And then finally, remoteness of damage. It's reasonably foreseeable, and you can use the cases Leach Brain and Bradford to prove that. It is reasonably foreseeable that someone would get ill if you're serving them off food and you're storing it in an unhygienic place. You're 100% sure that someone will get ill. And you don't know who you might come across. You could come across someone with weak immune system, and that's where Smith comes into play. Dan has weak immune system. Dan has a weak immune system. Dan has a weak immune system. Take your victim as you find them. And the second one, if the damage is reasonably foreseeable, then so is the extensive injury. And that's your plan. Now, I came up with most of this in the scenario. I've just written it down here for you guys so you have a visual that you can use when writing this answer. So write this answer. You can send it to me in the comments below. I'll check them out. Or you could send it to your teachers. Write an answer, send it to your teachers, and they'll give you a mark back. Now, when your teachers give you a mark back, if it's not 20 out of 20, you need to aim for 20 out of 20. If it's not 20 out of 20, write another answer, improve it, see your weak points, give it back to them to mark. And if it's not 20 out of 20, again, then you ask them to point out to you what you've not done too good in, so you can see your weak points that you need to flesh out, and keep rewriting the answer until you get a perfect answer, a 20 out of 20. One that your teacher cannot even criticize, and then reuse the answer for each and every one of your negligence 20 markers. So try that out and then tell me how it goes, and I'll see you in the next video. Bye.